Hello, my name's Jeremy Lightfoot. I'm a partner with Carey Olsen. We're one of the largest offshore law firms in the world. I think we're the fourth largest. We've got some 500 people across 9 different offices. Personally, I lead the litigation, insolvency and restructuring team here in Hong Kong. And a tiny bit of background, I used to be a barrister for a decade. And before living in Hong Kong, I lived and worked in the British Virgin Islands and the Cayman Islands. Well, I think one trend is definitely clear, and that's it's been busier. It's certainly been busier over the last 12 months across offshore dispute work. We personally have been expanding our team in that period. But the question that's slightly more difficult to answer is why it's busier and whether it's necessarily pandemic related. Now, in some spheres we do our work, there does seem to be a link with with the effects of the pandemic. So for example, insolvency and restructuring. It's really difficult to get kind of hard metrics, but if we take, Hong Kong list companies as an example, the number of insolvency announcements doubled from 2020 as compared back to 2019. So that's a bit of hard facts that shows there's certainly something changing in that market. And most of the cases we've been involved in seeing those spheres, we can draw a link back to the effects of the pandemic, perhaps unsurprisingly given global conditions. In other spheres, we're seeing a huge spike, for example, in fraud work. But there, it's not quite as clear whether that's actually caused by the pandemic or that's just cases we'd have seen anyway. In quite a few of them, there's probably a credible argument that the pandemic's given the conditions for the conduct to be uncovered. So essentially, the stopping of the global financial services for quite a while as a result of the pandemic has given the opportunity for these frauds to come to light. Whereas if everything had carried on as normal, perhaps we wouldn't have seen them quite as soon. So those are kind of on the markets, but on the much more kind of pragmatic, practical level of what the pandemic's done to offshore disputes work, the offshore jurisdictions adapted very quickly to the shutdown, which essentially meant that my 3 jurisdictions, BVI and Cayman and Bermuda, a lot had been virtual before, but really not on the scale we've seen over the last 12 months. So very practically, virtual hearings, remote access, e-filing, direct involvement here from Asia has all been much easier. So I think certainly for clients here in Hong Kong, that's been a great benefit. They don't always like having to sit with me throughout the night in our conference room to attend a hearing, but there's a real benefit in them being able to actually be in the courtroom and see what's going on. So on a purely pragmatic level, that side of the pandemic's been really helpful. It's quite a long list, and I think that's kind of the most important part of the answer. What we often have in offshore work is we'll often have one spike, one particular area that keeps us all very busy. So going back a few years, there's still some 238 dissenter cases now, but a few years ago, there was a large number of them and a lot of people were busy on that. I think from what I've seen for the last year, what's really interesting is there's no one thing that's particularly busy. Across my 3 jurisdictions, all 3 jurisdictions are busy, and they're all busy with exactly the kind of work that we'd expect to see out of those jurisdictions. So for example, I've already mentioned there's quite a bit of fraud-related work going on. We're seeing continually large and important shareholder disputes, particularly between founders of often very valuable new, maybe tech companies coming out of China. Listed companies have continued to generate work for offshore dispute lawyers, whether it be in control issues or possibly restructuring. We've seen quite a few of those as well. And I think restructuring support generally has been really quite a thing over the last 12 months. We've seen a large number of provisional liquidations in order to support schemes of arrangement. I think probably 2 others, I know it's a long list, but 2 others probably do deserve mention. Receiverships. Now, receiverships have been busy for many years, but they've been particularly busy in a slightly different way over the last 12 months. Because traditionally we'd see receiverships as very practical steps. They would be there in order to secure and realize the value of an asset. They'd be quite straightforward. They could take a while, but the purpose was quite straightforward. I think what we've seen over the last 12 months is a real growth in using receiverships for other purposes. We kind of call them internally holding pattern receiverships, in that it's lenders and other secured parties, they want to take action, they want additional control, they want additional information, but they don't necessarily want to proceed directly to realization of value of assets. And so we've seen a lot more inventive uses of receiverships as well. And finally, I really would be remiss not to mention cross-border work. Cross-border across all the spheres, but particularly insolvency and restructuring, has been a really important part of what we've been doing in the last 12 months. And the increased flow of cases for that, particularly highlighting insolvency and restructuring, has meant we've been developing a lot of what the courts do when faced with these situations, a lot of the cooperation regimes on a practical level. And I think also it's fair to say that a lot of people would say those relationships and regimes have been tested and perhaps even slightly strained, given the amount of work that's been going through. And so I think we are seeing some evolving jurisprudence coming out of the courts, and it's going to be a really interesting one to watch for the coming year. It's a tough one. It's always a tough one trying to make predictions. And I think if the last 18 months has shown us anything, it's unwise to try and predict too far ahead. But I could give you some kind of rough guesses, some educated guesses based on what we've seen and what the pipeline that we know is coming into us. I think you can probably make some guesses about the types of work and probably make some guesses about the volumes of work. The types of work, I think it's going to be much more of the same from the last year, particularly cross-border. That's not slowing down in a hurry. There's going to be plenty of cross-border issues continuing to be litigated. We'll probably see some more traditional insolvency appointments. There's certainly an uptick of that level of interest in the market, and I think we'll see more liquidations going through. Certainly more restructuring across the board. And I think also the protective receiverships may continue in the same way, but perhaps they might revert slightly more to traditional asset realization exercises. Volumes, we work really closely with onshore firms, with insolvency practitioners, investigators, and I think the market sentiment from everyone we're talking at the moment is pretty positive. And so if the market sentiment from each of those spheres is pretty positive, collectively, it's probably a fairly safe bet to say it's going to be at least a busy year. Whether it's busier than this year, I'm not sure, but the signs are really encouraging at the moment. But I'd probably just add one kind of final false prediction, in that I think if the last kind of 5 or 10 years offshore have shown us anything, it's that there will be a really big issue that none of us thought of in advance. So I think my kind of number one prediction is that we'll be talking next year about something that none of us thought of at this stage. And certainly we're keeping a really close and watchful eye on what that might be. My personal bet is it will be in the cross-border sphere, but that's just a guess.